Tian Hawkins, a 26-year-old mother with no prior criminal record, was sentenced to 5 years in prison after pleading guilty to permitting child abuse and child endangering, having known her fiancé Brian Moser, legally renamed from Terry Michael Smith Eard, was physically rough with her 2-year-old daughter Lilith, yet failed to intervene before Lilith died from a head injury on July 1, 2025 in Adams County, Ohio. Defense attorney Mackenzie Carrington argued Hawkins was at work during most of the abuse and showed genuine remorse, while the presiding judge, comparing Hawkins to someone who sorted through the apple bin and chose a bad apple, imposed the stipulated sentence with visible hesitancy.
Sleep naked, but there was just no guardrails there. And I ask in cases sometimes, would you go to the grocery store and sort through all the apple bin and pick out the bad apple and bring it home to your children? And mothers always say no. But you sorted through the apple bin and found this Brian Moser, bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. And I struggle with that.
You sorted through the apple bin. You found the bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. The judge paused after saying it. Tian Hawkins said nothing. 26 years old, 3 children, one of them dead, standing in an Adams County courtroom while a judge told her in plain language that she had known and had not acted. The silence that followed was not the silence of innocence. It was not the silence of guilt. It was something the law has always struggled to name precisely. She knew the sentence was 5 years. By the end of this video, you will understand exactly what the legal distinction between permitting child abuse and committing it means for how Ohio law sentences a mother who was at work. On June 17, 2026, in Adams County, Ohio, Tian Hawkins, born May 22, 2000, appeared for sentencing before an Adams County Circuit Court judge following voluntary guilty pleas to 3 felony counts. Child endangering in violation of Ohio Revised Code 291922A, a felony of the 3rd degree in count 3, and permitting child abuse in violation of Ohio Revised Code 290315A, a felony of the 3rd degree in counts 5 and 7. Defense counsel were Mackenzie Carrington and Jonathan Walker. The prosecuting attorneys were Tyler Cantrell and Ariana Bulls Norris. The presiding judge's name is not stated in the available record. Counts 1, 2, 4, 6, and 8 had been previously dismissed pursuant to plea negotiations. The stipulated sentence agreed upon by both parties was 5 years.
With that said, State, would you like to be heard?
Yes, Your Honor. In this matter, the plea negotiations had a stipulated sentence of 30 months in count 3, to run consecutive to 30 months in count 5, to run concurrent to 30 months in count 7, for a total of permanent incarceration of 60 months or 5 years, Your Honor, total. The state of Ohio came to that conclusion in light of all the evidence, looking at what involvement Ms. Tian Hawkins had compared to that of Mr. Brian Moser.
Tian Hawkins was 26 years old on the day she walked into that courtroom. She had no prior criminal history of any kind. She had worked continuously since 2018, KFC, Taco Bell, Subway, McDonald's, managing food service operations, holding culinary certifications, paying her bills, raising 3 daughters whose father was not present. She met Terry Michael Smith Erie, who called himself Brian Moser after changing his legal name the day before her daughter died in April of 2025. He was sweet in the beginning. That is what she told investigators. He watched the girls while she worked. She asked her oldest how her days were. Her oldest said they played. She had no reason, she said, to believe otherwise.
Just that I love my children and I wanted to give them the best life I possibly could. And if I knew what he was doing, it would have never got as far as to what it did. And that I would still have all 3 of my children.
What she did have, and what the court record confirms she acknowledged, was the knowledge that he disciplined Lilith more harshly than the others, that he pushed her when she had accidents, that she had told him it was too hard. The cost of what she did not do next is measured in the only currency that cannot be repaid. Lilith was 2 years old. She is gone, and Tian Hawkins has already served 345 days in the Adams County Jail while awaiting this moment. On July 1st, 2025, a sergeant was dispatched to Timber Ridge Apartments, Apartment 15, for a 911 call reporting a 2-year-old female non-breather.
Those various ones, and I think the one that captures the majority of it is this, that on July 1st, 2025, a sergeant was called to Timber Ridge Apartments, Apartment 15, regarding a 911 call being a 2-year-old female non-breather. On arrival at the apartment, the sergeant asked the male standing at the door where the baby was.
The male at the door said the baby was upstairs. Sergeant Walters was already carrying her down the steps. He laid her down. He started chest compressions. The life squad arrived. Lilith was confirmed deceased.
He advised the baby was upstairs. They started up the stairs. Another sergeant, Walters, was carrying the 2-year-old down the steps. He then laid the baby down to start chest compressions. As Life Squad pulled up, Sergeant Walters then ran to the squad with the baby. Deputy Sean Grooms also was there, and he went inside the apartment to look around to see if he could observe anything that would have stood out in the case, that something like the baby got a hold of something. They were able to let the squad know. While upstairs, Sergeant Phillips went to the bedroom to the left, in which there was a small crib up against the wall. It was then determined they weren't in the correct room. The room the baby was in was the room with the bunk beds. The sergeant was able to do a search, as well as any further squad members needed important information from the mother of the child, which the 2-year-old had been confirmed deceased at that time. They received information and gave it to the squad members.
Deputies observed the 1-year-old Isabel with severe bruising across her forehead and legs. She was wearing only a diaper. Tian Hawkins and her 2 surviving daughters were placed in an unmarked vehicle. Her phone was taken. Brian Moser's phone was taken. Children's Services assumed custody of both surviving girls.
They also had Tian Hawkins, along with a 5-year-old child and a 1-year-old baby, sit in the back seat of the unmarked car. They did take possession of her phone. The male adult being Terry Michael Smith, the third also known as Brian Moser through his name change, which is the name that he had recently gotten changed the day prior to the incident. Brian's phone was also confiscated, and Deputy Grooms took possession of the 5-year-old and the 1-year-old. They did observe the 1-year-old having severe bruises at the top of her forehead, along with bruises on her legs. The child was in a diaper only. Sergeant Phillips did get consent from Tian Hawkins to do a DNA swab on her ankles, in which she indicated there was blood through female cycling. Tian Hawkins was then read her Miranda rights, and she did not consent to swab her ankles, again to see where that blood was the source of. Children's Services took custody of the 5-year-old and as well as the 1-year-old. Both children were checked.
Detective Cooley interviewed Tian Hawkins at Tunde 38 that morning. She was read her Miranda rights, the constitutional warning established under Miranda v. Arizona, 384 U.S. 436, 1966, requiring law enforcement to advise a suspect of their right to remain silent and their right to counsel before custodial interrogation. She waived those rights and gave a statement. She said the children went to bed around midnight. She said Lilith was running around playing at 11:30 the night before. She said Brian woke her up that morning and told her Lilith wasn't moving. She said she ran in, pulled Lilith from the top bunk, and started CPR. She said she put a diaper on her afterward because she wanted her covered. She said Brian disciplines the children more than she does.
Covered up and tucked in. Tian advised that the last time Lilith was awake was around 11:30 p.m. She was running around playing. Tian Hawkins stated that she does not have any medical conditions. Also advised that they were working on potty training her. She said that they had tucked the children in bed. that she knows nothing about the knot on her forehead, and doesn't know if she turned and hit her head on the metal of the bed or what happened. She also said her fiance, Brian Moser, woke her up, telling her that Lilith wasn't moving. She ran into the bedroom. Lilith was taken off the top bunk by her, being Miss Hawkins. Tian stated she started CPR on Lilith. Tian then said that Brian and she did smoke a THC vape around 11 p.m. while the kids were watching TV. Miss Hawkins stated that she didn't do anything to Lilith, and also advised Lilith that didn't have that bruise when she went to bed on her head. Stated that Brian disciplines.
She said he was tougher on Lilith than the others. She confirmed she had told him he was hitting too hard. She said she saw him push Lilith when Lilith had accidents and watched her fall to the floor. She said she had no idea how Lilith died.
How this happened with the death of Lilith. She's seen Brian push her, and she's seen her fall to the floor. This occurs when she does not control her bowels, being Lilith, and she doesn't go to the potty. He pushes her, and she's fallen down, denies the fact seeing him hit the children anywhere but their butt.
Most people watching this hearing missed what just happened in Tian Hawkins' own statement to investigators. She confirmed she had witnessed Brian Moser push a 2-year-old child to the floor. She confirmed she had told him he was hitting too hard. She confirmed she knew he was harder on Lilith than on her sisters. And then she went to sleep. That sequence, observation, awareness, inaction, is not incidental background. It is the legal core of every charge to which she pleaded guilty. Ohio Revised Code 293115A, permitting child abuse, makes it a felony of the third degree for a person who is the parent, guardian, custodian, or person having custody or control of a child to permit the child to be abused. The word permit does not require the defendant to have inflicted any injury. It requires only that the defendant had custody or control, knew or had reasonable cause to believe the child was being abused, and failed to prevent it. Plain English, if you are the mother, if you saw the pushing, if you heard the hitting, if you told him it was too hard, and if your child died from a head injury, the detective confirmed required significant force. The law does not ask whether you caused it. The law asks whether you permitted it. That is the question Ohio law puts before every parent who looks away. Brian Moser told Detective Cooley he did not hit Lilith in the forehead. He said he could put that on everything. He said he only disciplined the children on their butts, their hands, or their mouth. He said he did not close fist hit them. The detective's response, read into the sentencing record, was direct. This isn't Dexter. This is real life.
And it concludes by saying that Deputy Cooley advised that this isn't Dexter, this is real life.
Brian Moser had changed his legal name the day before Lilith died. He chose it because of a fictional serial killer. The court noted that fact. It did not elaborate on what it meant. It did not need to.
Also known as Brian Moser, was read his Miranda rights. He stated that he had changed his name because he likes the character from the TV series Dexter. He said that he put all the kids to bed around midnight. He then went to bed with his fiancée Tian. She was already asleep, being Tian. Brian said that Aurora was to the left of the bed, Lilith was in the middle, and Isabel was on the right. He thought it would be cute for all three of them to be up on the top bunk like that. Detective Cooley explained to Mr. Moser about the bump on the head and asked about that. It had to be a hard impact to cause that type of bruising. Brian Moser said, I did not hit her in the forehead. I did not. I could put that on everything. I don't recall hitting them anywhere but on their butts, hands, or their mouth. I did not close fist hit them. I don't do that.
Here is what that detail means in the real world. Brian Moser's sentence is not part of this record. What this record contains is the sentence imposed on the woman who was at work while he was alone with her children. In a case where the person who actually inflicted the fatal injury faces separate proceedings, the mother who pleaded guilty to permitting the abuse walks into a sentencing hearing carrying the full moral weight of a dead child and the legal weight of charges that require only that she knew and did not act. Whether those two weights are proportionate is the question the judge spent 25 minutes working through out loud and then answered with 5 years. A properly structured case of this kind requires prosecutors to draw a precise and documented line between the culpability of the person who committed the abuse and the culpability of the person who failed to prevent it. Ohio Revised Code 2929.12. The seriousness and recidivism factors the court is required to balance at sentencing includes as a mitigating factor whether the offender did not cause or expect to cause physical harm to any person. Defense counsel Mackenzie Carrington argued that distinction clearly the abuse was occurring while Hawkins was at work, that Brian Moser's intentional acts were separate from her failure to protect, and that a woman with no prior record, genuine remorse, and a low recidivism score of 10 on the Ohio Risk Assessment System deserved the agreed 5-year sentence, not a departure above it.
Yes, Your Honor, thank you. We are asking the court to follow the agreed 5-year sentence. I think there's no doubt that this case presents an unimaginable tragedy, Your Honor. But Ms. Hawkins is 26 years old. She has no prior criminal history, and I think it's important to distinguish the intentional acts of Mr. Moser versus Ms. Hawkins's involvement with the failure to protect the children. The majority of the abuse that was happening was occurring while Ms. Hawkins was at work supporting the family, and she entrusted Mr. Moser to become the full-time daycare provider for the children, unbeknownst to her of the horrific things that were happening. And I think Ms. Hawkins shows a genuine remorse for what's happened. She's able to realize now what she didn't realize at the time. And it's important to note that she has a family here that's provided unwavering support for her. They've attended every hearing. We've provided letters not only from her family but from the community, trying to show the court what kind of person Ms. Hawkins is and what she is capable of providing to society. We think no matter what happens today, when Ms. Hawkins leaves here today, she's going to be stuck with a life sentence of guilt and remorse. But we are asking the court to follow the 5-year agreed upon sentence. We think it serves the principles of sentencing. Thank you, Your Honor.
Thank you.
The court agreed. With hesitancy, it stated on the record, what should have happened differently is not the sentence itself, which both parties stipulated. What should have happened differently is the absence from this record of any documented intervention by any authority, school, child services, anyone, during the months when Brian Moser was alone with 3 children every day. Tian Hawkins had prior CPS involvement. The record shows it. It shows the system noted the concerns and did not act. The cost of that institutional inaction is the same as the cost of hers, and the accountability mechanism for a child protective system that receives a report and closes the file is, in most American jurisdictions, effectively non-existent. Most people believe that a mother can only be criminally charged for her children's injuries if she was present when the injuries occurred. That is not what Ohio law requires. Ohio Revised Code 2903-15UA applies to any parent who permits abuse to occur, which means knowledge plus inaction is sufficient for a felony conviction, even if the parent was physically absent at the moment of the fatal act. This is the legal standard that is hardest for most people to accept because it runs directly against the instinct to distinguish between doing harm and failing to stop it. The law does not always make that distinction, and understanding why it does not, understanding that parental duty under Ohio law includes the affirmative obligation to protect, not merely the prohibition against harming, is what separates a viewer who watched a sentencing video from a viewer who now understands what the law actually requires of a parent. The prosecution's argument at sentencing was built on the agreed structure: 5 years, 30 months on count 3, 30 months on count 5 running consecutive, 30 months on count 7 running concurrent. The state explained the concurrent structure for the third child. 15 months each was not permissible under F3 sentencing guidelines. 12 and 18 would have created unequal treatment between two children whose experience of the abuse was documented as equivalent, so 30 concurrent achieved the intended parity. The prosecution argued the sentence reflected Tian Hawkins's comparative involvement measured against Brian Moser's direct actions and represented a fair resolution in light of all the evidence. The defense asked the court to follow the agreement precisely, emphasize the absence of prior criminal history, the genuine remorse documented by every assessor who evaluated her, the 345 days already served, the letters from her Sunday school teacher, her sister, and her community, and the pre-sentence investigation's conclusion of low recidivism risk. The defense did not dispute the facts. It disputed only the weight those facts should carry against the life of a 26-year-old woman who, by her attorney's account, will carry a sentence of guilt and remorse that no court can impose and no release date can end. The one question neither attorney fully resolved before the judge ruled: if the sentence is stipulated, the remorse is documented, the recidivism risk is low, and the person who inflicted the fatal injury is someone else. What exactly is 5 years designed to accomplish that 4 years or 6 years would not? And is the answer to that question the same for the dead child's sake as it is for the surviving children's sake?
The court, with some hesitancy, but finalized, that after due consideration, the court finds the defendant is not amenable to available community control sanctions. The court does intend to follow the stipulated prison term, and it will be imposed that the defendant shall serve the stipulated prison term in count 3, of 30 months, a stipulated prison term in count 5 of 30 months, which shall be served consecutive to count 3, and a stipulated prison term in count 7 of 30 months, which shall be served concurrent to counts 3 and 5 for a total of 5 years incarceration in the Ohio Department of Rehabilitation.
5 years, Ohio Department of Rehabilitations and Corrections. Credit for 345 days served. Post-release control mandatory upon release for up to 3 years.
Incarceration in the Ohio Department of Rehabilitations and Corrections. Because multiple prison terms are being imposed on Ms. Hawkins for convictions of multiple offenses, the court may require that she serve them consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct or the lack of conduct and to the danger that it poses to the public. And the court makes the finding that at least 2 of the multiple offenses, in this case 3 offenses, that 2 of the multiple offenses, at least 2 of them, were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed is so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct would adequately reflect the seriousness of the offense.
Transitional control and intensive program prison specifically reserved for denial. The judge noted the low recidivism assessment, the admirable work history, the model conduct during 345 days of pretrial incarceration, and the letter from the Sunday school teacher who, in the judge's words, captured very well the person the court did not know, but she did know. The court found comfort there, and sentenced her anyway.
The citizens and the community partners, what they have observed, what they know, what they have experienced, that they have interacted with Ms. Hawkins. This court, obviously, it's been very limited that the court has interacted with Ms. Hawkins. I do believe that Ms. Hawkins has great remorse for what occurred. There is a high likelihood there will never be recidivism in this case. Even in light of the court's concerns, as to the variation in the agreement. The court does find comfort, especially in your in the very well written letter by your former Sunday school teacher, that I thought she captured very well the person that we didn't know, that she does know and did know. So it will be the order of the court.
This ruling is legally and procedurally correct under Ohio Revised Code 2929.14, which governs consecutive sentencing and requires the court to find that consecutive terms are necessary to protect the public, are not disproportionate to the offense, and that the harm caused was so great that no single term would adequately reflect the seriousness of the conduct. The court made those findings explicitly on the record. What the ruling upholds is the principle that parental duty is not discharged by physical absence, that the law imposes on every parent an affirmative obligation to protect, not merely a prohibition against harming, and that when a child dies and a parent knew the danger existed and took no action to eliminate it, the court's obligation to the victim does not end because the parent's heart is broken. This is the same principle of omission liability that the Supreme Court addressed in Deshaney v. Winnebago County Department of Social Services, 489 U.S. 189 1989, a case that established the limits of governmental duty to protect, but simultaneously confirmed that private individuals with custodial relationships to children carry affirmative legal obligations that the state can and does enforce through exactly the statutes applied here. The law does not grade grief. A mother who weeps in a courtroom and a mother who failed to protect her child can be the same person, and the justice system is not equipped to resolve that contradiction, only to respond to it. Tian Hawkins will serve 5 years for what she did not do on the nights she went to work and left her daughters with a man she knew was too rough and did not remove. Her surviving daughters are in foster care. Lilith is not anywhere. The sentence cannot change any of those facts. What it can do, what the law intends it to do, is establish that inaction in the face of known danger to a child is not a private matter. It is a public one. The next video examines a case where a parent's failure to disclose a known danger to Child Protective Services became the basis for criminal charges, and the legal standard for what counts as sufficient disclosure under mandatory reporting laws is one of the most consequential and least understood obligations in American family law. Was the 5-year sentence imposed on Tian Hawkins, a woman with no prior record, genuine documented remorse, a low recidivism score, and whose abuse occurred primarily while she was at work, a proportionate response to her specific degree of culpability under Ohio law? Or did the court allow the moral weight of a dead child to drive a sentence that exceeded what her actual legal conduct, measured against the statutes she pleaded guilty to, genuinely required? And if the latter, what should the sentencing standard for failure to protect actually look like when the person who caused the death is someone else?